Okay, so Battle Cry of Freedom, James McPherson. Let me tell you, this is one of the best Civil War books I've read. And I've read a couple. Since they're not of this year, I guess I won't review them. But one of my favorites is Bayonet Forward, about Joshua Chamberlain, who's my favorite character out of the Civil War as far as the heroes and stories. I just love that person's whole background story, Joshua Chamberlain. But anyway, that's not, this book wasn't about Joshua Chamberlain. It's about everybody and all the different aspects of the war. And this just is, to me, a must-read if you're a history buff and if you are into the Civil War. This can't get around not reading this. So I say we open up and read one of my favorite excerpts from it. Oh, this passage I found interesting, just in lieu of what goes on today. So I figured I'd just read this. There's other things, but I don't know. This one standed out to me. I'll just read it as such. The senior judge of the court was none other than Roger B. Taney, who on May 26 issued a writ ordering the commanding officer at Fort McHenry to bring Merryman before the court to show cause for his arrest. The officer refused, citing Lincoln's April 27th suspension of the writ of habeas corpus in portions of Maryland. This confrontation became the first of several celebrated civil liberties cases during the war. Article 1, Section 9 of the Constitution stipulates that the privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it. In a circuit court ruling on May 28th, Taney denied the president's right to suspend the writ. The provision authorizing the suspension, he pointed out, appears in the article of the Constitution specifying the powers of Congress. Therefore, only Congress can exercise in the power. Moreover, Taney continued, the Constitution does not authorize the arrest of civilians by Army officers without the sanction of civil courts, nor does it permit a citizen to be held in person indefinitely without trial. The Republican press denounced Taney's opinion as a new species of pro-slavery sophistry. Lincoln refused to obey it. Several prominent constitutional lawyers rushed into print to uphold the legality of Lincoln's position. The particular location of the habeas corpus clause in the Constitution was irrelevant. They maintained suspension was an emergency power to be exercised in case of rebellion. The president was the only person who could act quickly enough in an emergency, especially when Congress was not in session. The whole purpose of suspending the writ, said these legal scholars, was to enable Army officers to arrest and detain without trial suspected traitors when civil authorities and courts were potentially sympathetic with treason, as in Baltimore. And it goes on. I mean, to me, I thought that was interesting. That's why I read it. It's not something where you're going to be, unless you're a history fanatic, you're probably going to be bored out of your mind, especially if you're not really into the Civil War. But if you are into history, especially in lieu of what goes on today, this is a paramount read. Definitely read this. All right.